Well, what's really on my mind this morning is actually Game of Thrones. I know you're.
Oh, winter is here.
Winter is here. I know you're a huge fan, Patria,
Absolutely.
but okay, I'm not going to use this platform to talk about GOT, even though I really want to. I really want to. Team Daenerys.
Oi,
I think Sansa will end up taking it though,
Team
because
Jon Snow.
everybody else will probably end up dead.
Team Jon
Anyway,
Snow.
anyway, we can talk about that elsewhere. What I'm gonna talk about this morning is the NIDS ruling, the National Identification System, and actually the legal framework that would have set NIDS in motion. That's the National Identification Registration Act, NIRA. So on Friday, as you would have heard, the Constitutional Court ruled it null and void and of no legal effect. A landmark and historic ruling that will be examined, no doubt, around the world, because in our judges' examination of the case, they looked at other similar cases around the world, including one in India, where they have a national identification system as well. And so this decision is likely to influence other decisions worldwide for countries who attempt such a thing. So the court ruled it null and void and of no legal effect due primarily to privacy concerns and also the mandatory nature of it, because there are criminal prosecutions. You face the risk of criminal sanctions if you don't sign up to the NIDS under NERA. And so the court ruled that these violations were not justified and that the protections in the statute were inadequate. So they threw out the entire NERA. They declared it null and void and of no legal effect. They said they couldn't just throw out those parts that were bad because it tainted the entire rest of the thing. The entire act hinged so much on these elements of it that it wouldn't make sense to keep the rest of the act. So everything is gone. The Andrew Holness administration now has to wheel and come again with something else, perhaps making it non-mandatory that would address those concerns. I have to say I'm disappointed, but not entirely surprised, because the writing was on the wall from the hearings in October, and you saw how that was going poorly. You heard when the learned Chief Justice said the Attorney General Marlene Malahou Fort was wasting the court's time. That's certainly not positive. That's an indication perhaps of where the decision is likely to go. But I am disappointed because I think we need a national identification system. This puts a delay in us getting to that goal. And I also think that it needed to have been mandatory. Me personally, I'm okay with giving up some elements of my privacy in order to ensure my security. And we already do it in many senses.
Yeah.
Samsung knows more about me than I probably know about myself. You know, the other day, Pat, I was having a conversation with a friend, and I was telling them about a situation with somebody else. You know, within 5 minutes, my friend got a friend suggestion to add the other person as a friend.
Absolutely.
From Facebook.
I believe.
You know, so
I believe the difficulty that I had with NIDS though is I would have been in support of it were it to be used as a security tool. But the arguments became, oh no, it's not going to be about security. It's going to be about, a social number. It's
No.
not going to be a security tool. And
Well,
they were
it certainly-
adamant that it wouldn't. And
well,
that's why I was against NIDS.
the intention wasn't for it to have been primarily a security tool, but because of what the data that would have been gathered, it would have helped in that aspect. But the primary use of NIDS wasn't for security reasons, but it would have helped that capacity.
They actually were adamant enough to say it's not going to be used for security, and I had a problem with that. Yeah.
But the thing is, though, even though I would have been willing to give up, some elements of my privacy, I'm not everyone, and I can't force my views on everyone, and neither can the government, which is what the court has ruled. I'm mostly disappointed that the government didn't make a stronger case, because they should have been well prepared for a constitutional challenge. From the time that Marlene Malahou Fort announced about 2 years ago, near the beginning of the administration, that they plan to take some measures in which rights will have to be abrogated and infringed. Remember, those were her
And
words.
those words came
Right back to haunt
back
her,
in
because those were the
ruling.
very words that Julian Robinson used in his constitutional challenge of the case.
And the very words that Justice Sykes used in summing up the case.
Indeed. So from the time she said that, to me that was an admission that they intended to do some things that could be deemed unconstitutional. But the argument would have been that, yes, we're going to abrogate and infringe these rights, but it's justified. It's justified. And there is provision in the Constitution for certain things to be done with adequate justification. And the court considered that there can be justification, but they found that the government hadn't made the case that these measures were justified. And so that's where the government side really dropped the ball. Because to me, it's quite obvious that we need a system to adequately identify people. And biometrics are the best and the most foolproof way to achieve this. And it's not as effective if it's not mandatory. We do live in extreme times. And in extreme times, extreme measures are necessary. If you don't see over 1,000 murders in a year consistently in a country of less than 3 million people as extreme, then you probably don't think ISIS is extreme either. You know, because beheadings, killings, that's Jamaica. That's commonplace in Jamaica. And yes, NIDS, like we were saying, it's not designed primarily as a crime-fighting tool, but it would help in identifying people. But now the baby and the bathwater are gone. So the only solution now is to conceive a new baby. They better do it right this time. That's what's on my mind.